Welcome to Sakshi TV's special immigration show with attorney Bhanu Babu Illindra from BBI Law Group. Please know that Sakshi TV now has 3 immigration shows every week: on Tuesday at 3 p.m. EST with attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. EST with attorney Ms. Prashanti Reddy in English, and on Friday at 6 p.m. EST with attorney Bhanu Illindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice. Use of content is for general informational purposes only. Sakshi TV or its agents in the USA or our guests on this show are not responsible for use of information as a legal advice. If you need specific legal advice, please contact attorneys directly. We will be also taking any general immigration questions today along with today's topic. Hello Bhanu Garu, welcome to the show.
Thank you. Thank you very much for inviting me to the show.
Yes, same here. Bhanu Garu, could you please give us some information on how our viewers can reach you for a private consultation?
Sure. The viewers can reach us through our website, www.bbilawgroup.com, or they can reach me on my mobile number, which is 319-400-0053, or to my office number also, it's 703-496-7722. They can also reach to my email ID, which is bhanu@bbilawgroup.com. BHANU, Bhanu, at bbilawgroup.com. They can also reach us through contact@bbilawgroup.com also. If they have any if they need any private consultation or need any help with their immigration matters, we are here to assist them. And thank you very much for asking me this information.
Right. So Bhanu Garu, we already have our first caller on hold. So Mr. Mahesh from Texas is on the line. Thank you for calling, Mr. Mahesh. You may ask Mr. Bhanu your question directly.
Namaste Bhanu Garu.
Hello Mahesh.
Happy Friday.
How are you? You too.
I'm fine, sir. Thanks. Sir, right now I'm planning to go to India this November. And I see the dropbox slots are not available, but I'm trying for one. But when I did my account in US Travel Docs, I can only see the dropbox because it asked for some questions and I filled that questions and it's only showing me the dropbox option. Do you think like Dropbox is taking much time? What's your opinion on the Dropbox?
See, as of now, what I'm seeing is whether it's a Dropbox or a regular appointment at the consulates in India, they're taking time. They're not available for regular appointments unless there is an emergency appointment, or which is called LF4 appointment. They're not scheduling any appointments. You just apply for the Dropbox, wait for it. If it is open, then they will schedule you for the appointment. I think you should go ahead and fill the information and be ready with the Dropbox. And if you're eligible for Dropbox, it doesn't matter how much time it's going to take because it's easy for them. If they need any information from you, they're going to ask you anyway, and they'll ask you to come and visit them and schedule an appointment with them. So you can travel in November. Probably the travel ban will be lifted in November as per the new announcement by the President Biden's government, basically, So that's what I would advise you to do. Go ahead and complete your application and try to see whether they can schedule you to drop off your documents or not through the Dropbox.
Sir, can my wife and my son, who is a US citizen, they can travel and they drop my H1 application as well, or do I have to be there in person?
You have to be there in person.
Okay. And I have one last question, sir. So can I switch my Dropbox appointment to an interview appointment by any chance? Is there any way to switch from Dropbox to an interview?
They will do that. If required, they will do that. Okay? Even if you throw a Dropbox appointment, as I said in the beginning, if you have to understand this. you'll be eligible. If you want to do Dropbox appointment, you have to go to the same consulate where you got a visa. If you want to switch to the interview, then don't go to that consulate. Try to apply in a different consulate or take an appointment in a different consulate. If you take an appointment in different consulate, then automatically you'll be subject to the interview, not to the Dropbox.
Right. Mr. Bhanu, are there any immigration updates that you'd want to share with our viewers?
Not many, Andy, but however, I would like to talk to everybody is that the October visa bulletin has come, and we all know that dates haven't moved forward for the October visa bulletin. Also, they did not retrogress also for the October 2021. They are going to retrogress as per the Charlie Opinion from November onwards, and we do not know how much they're going to retrogress from November onwards. And we have to wait and see basically how it's going to happen and everything. And second thing is, if it comes to the priority dates and filing of 485s, usually until now, USCIS was accepting the 485 applications only based upon the final action dates stated in the visa bulletin. For the month of September, August, July, for all these months, USCIS accepted I-485 filings only based upon the final action dates. However, for October 2021, USCIS has issued a notice saying that they're going to accept the filings of 485 based upon the filing charts. You have to understand that there is only 1 month difference between the filing chart and the final action dates into the October 2021 visa bulletin as far as the priority dates availabilities are concerned. But still, it's an opening welcome from the USCIS that they're going to honor the filing chart for the employment-based category for the October 2021 visa bulletin. Other important thing is that we all were expecting that some kind of immigration reform is going to happen through the budget reconciliation bill. However, the parliamentarian in the Congress actually denied the possibility of introducing the bill by the Democrats, but they're hoping that they're going to work on it, they're going to do that. So that is one huge drawback for the immigrants, which is involved actually getting legalized for 12 million people who are in this country through DACA and other reliefs basically, and also by trying to recapture all immigrant visas and removing the per country limitations on issuing the immigrant visas. That proposal also has been stalled along with this. However, Democrats are hoping, or many people are hoping, that in this, through the budget reconciliatory process, they may introduce the at least recapturing of immigrant visas so that people who are waiting in the queue for a long period of time will be able to get the green cards. We do not know whether how possible it is to become a reality, but that is the effort is being put right now. These are the two latest updates which I would like to bring in this call, indeed.
Right. So, Mr. Bhanu, in relation to this, I'd like to ask that there is a news that, the US has eased up the travel restrictions from November, and everybody who's completely vaccinated can travel to the US. What would you say about that? Is it confirmed?
There was no official announcement yet with
Right.
the policy, but it is expected to come. What the policy says that is that from sometime in the first week of November, the US government is going to ease the traveling between the US and the foreign nations from where actually there are travel restrictions right now because of the COVID-19 pandemic, and especially for the H-1B visa holders and some other non-immigrant visa holders who does not qualify for the exceptions for the travel ban, they are restricted to travel to US unless they travel through a different third-party country and quarantine in the third country for 14 days, they cannot come to the US, But with the ease of these restrictions, the government proposed or said that they're going to ease the restrictions and allow the more travel to the US, provided if the individual who's traveling to the US shows the proof that they were fully vaccinated and also carrying the RT-PCR COVID-19 test with a negative result, which has been done within 72 hours prior to the departure by the aeroplane to the US. or by any vessel to the US.
Right.
That's the right way to use. That's a very good welcoming change. Because of that, if that happens, then automatically national interest exemptions need not be applied, need not be taken by H-1B workers and other people who are planning to come into this country, because everybody who is fully vaccinated or eligible to come into this country.
Right. So what other effect does the easing up of travel ban or the restrictions easing up have on visas? Is there any particular effect of this on the visas per se? Would there be?
Yes, because that allows now B1B, especially B1, B2 visa holders, right? B1, B2 category and other category people, they should be able to travel. They should be able to get the visas at the consulates. Now, consulates are not issuing B1, B2 visas to anybody because of the travel restrictions. They're saying that the travel restrictions, unless you qualify for national interest exception, you're not eligible for the visa. So they're not issuing any visas for the B1, B2 or H1Bs or some other categories like H4s and other categories. With this easing of travel restrictions, consulates are going to process those visas again from the first week of November, provided if this policy is confirmed by the current administration, which is Biden administration. And that makes it more easier for people to travel, especially now. There are many parents who want to travel to the US, but because of the COVID-19 travel ban, which came into effect on May 4, 2021, many parents were not able to come to the US. Of a lot of H-1B visa holders I'm talking about, not the parents of the US citizens or the permanent residents, but what I'm trying to say is parents of the H-1B non-immigrant visa holders. So that's going to be ease up traveling. That means now only emergency flights are traveling is being conducted right now, or restricted flights are being held right now from India to US. But at the time, I think all the regular flight schedules will open up if they would ease up on this particular requirement, which is saying that if you're fully vaccinated and if you can provide RT-PCR test, COVID-19 test, that has been taken within 72 hours of your departure, then it's pretty good actually.
Right, right. So, Mr. Bhanu, could you please explain to us and our viewers what an RFE is? Since we're doing a show on the immigration updates and immigration FAQs, I thought we should bring this up.
No, this is a very good question actually, and I really appreciate you bringing up this question right now.
Thank you.
RFE means, RFE means it's a request for further evidence. See, the immigration laws requires an individual to submit all the information to the USCIS to get the approval of the benefit which they're seeking. For example, let's talk about let's assume that we're talking about B1, B2 visa holders, right?
Right.
Somebody applies for B1, B2 change of status or an extension application with the USCIS in the country. They're in the US already. They applied for either for change of status from others to some other status to B1, B2, or applied for extension of status of B1, B2 because they're already in the B1, B2 in the US. When you're applying for it, it's your responsibility to show how you're eligible for that extension or for the change of status. That means there are certain required documents you need to present, like maintenance of status documents, all immigration documents like your passport pages, and your financial ability, wherewithal to see how you can support while you're in B1, B2 in this country, and your intent to return to home country once your visit is over. All that information you have to provide to the USCIS. However, sometimes what happens is the information which we think is enough may not be enough to the USCIS officer to adjudicate that case. So what happens at the time, USCIS officer, if they think that the information what you provided is not enough to adjudicate the case in favor of the candidate, they should either deny the case, or other option is them basically approaching the candidate who actually applied for the benefit and giving them an opportunity to provide the required information what officer think is needed in order to make a proper decision on that case. That process is called request for further evidence. When the officer thinks that there is some evidence is missing in the application or the documents that have been submitted by the individual in the beginning to seek the benefit, and if there will be an opportunity given to the end beneficiary or applicant or the petitioner, whoever it is seeking the benefit, to provide the required information so that they can make a decision whether it's a positive or negative. So that process is called request for further evidence. What they will do is, let's assume that you presented everything, but you missed your passport pages. USCIS needs your passport pages. So what they will do is, they'll issue a notice called request for further evidence to you. In that, they basically state that the required passport pages to be submitted so that we can make a decision on, in this case, whether you're eligible to seek the benefit, what you are seeking or not.
Right.
Passport is a very push. So that process is called request for further evidence. Usually, request for further evidence is given for, that will actually gives you 84 days time from the date the request for further evidence notice is issued. It gives you 84 days time to respond to that notice along with this required supporting documentation or to make any legal argument. Request for further evidence sometimes can be given for the legal reasons also, to show how you're eligible for the benefit also. You can make the legal argument also in that. Most of the times legal arguments are given through the NOID, notice of intent to deny. But sometimes USCIS use both of them interchangeably. So that's why we can talk about that. This is the process which is called request for further evidence.
Right. So what are the chances for somebody to decrease the chances of an RFE? Is there something, apart from the obvious checking the data correctly, is there anything else that somebody should look into to avoid getting an RFE probably?
Make sure that you provide all the information that you think is necessary under the preponderance of the evidence standard to get the approval. That means, let's take an example of an H-1B petition, right? When what is an H-1B petition is meant for? H-1B petition is meant for the specialty occupation worker in the US. As an ex-employer, if I'm hiring an A employee, as an ex-employer, I have a responsibility to show that the petition which I'm filing qualifies as a specialty occupation because it requires at a minimum bachelor's degree or its equivalent in a specific specialty in which I'm intended to hire an employee A. Okay? I have a burden to prove that. Along with that, I have to prove that once I meet that burden, then I have to prove that employee A actually indeed qualifies for that position. How do I show that employee A qualifies for that position? If the employer can provide all that information showing that I have a requirement in a specialty occupation, how do you show that? Depending upon the nature of the business and everything, right? For example, I'm a law firm. So if I'm hiring a lawyer, it's understood that I have a requirement to hire a lawyer because of the practice business which I'm in. But if I'm in a business where I actually place employees at the third-party company and they actually provide services to third-party company but not directly to me, then I have a responsibility to prove to the USCIS how I have a valid requirement for him to work at the third-party client side, right? Third-party company. Usually you can document that by your agreements or a purchase orders or some kind of a letters or some kind of a confirmations from the third-party company establishing the business relationship between you and the third-party company. So if you can document all these things, depending upon the situation and everything, you can avoid RFEs, But as I said, getting an RFE is not a bad thing. It is actually gives you an idea where your case is standing with the USCIS and also gives you an opportunity to submit the additional information that is required to get a positive outcome for your case. Okay, so just to avoid RFE, make sure that you provide all that information properly so that you can avoid the RFE and get the approval.
Right. So, in continuation with this topic, what are the chances of a person's approval of visa after getting an RFE?
It all depends upon the factual situation. If it's just the documentary evidence which they need, which is already in existence, then the chances are very high. See, for example, for us, I would say it's very likely that the case will approve is very high after issuing an RFE based upon the facts of the case at the time, you know. And therefore, if you ask me very generally, if you may want me to make a generic concept, I would say most of the times the case will be properly adjudicated, will be approved if you properly respond to the RFE after issuing the RFE.
Right. So one of the most repetitive FAQ is that why does the USCIS take so long to process, visas? Like, why is the processing time of USCIS so long? What would you like to say about that?
Actually, that is the problem we have with the USCIS, right? There's too much bureaucracy involved in between on processing these cases, right? And they basically claim that they have too many backlogs or non-availability of the staff, or certain processes and procedures, some blue belt, red belt, whatever it is called. They have to go through all those 9 steps basically to get the cases adjudicated. That's why they're taking time. And sometimes I do agree with them, especially if it comes to the background checks of the individual. It may take some time, but however, I think still there are certain procedures which allows them to go through them and adjudicate the cases fast. See, when the Congress actually passed the Immigration Nationality Act in 1990, in the comment section, they clearly mentioned that they intend USCIS adjudicating the benefits within 30 days of their filings, basically. But that seems to be far distant reality if it comes to reality with the USCIS, with many benefits. That could be based upon the workload they have, based upon the availability of the staff. As I said, so many things.
Right, right. So my next question is, what do you think, will EB2 move forward in 2021?
I think they will move forward. They may hold for a while because of the Charlie Oppenham comments. What he made, he said that is EB3
Right.
are going to retrogress. So the visa numbers can be held for a while for EB2 category, but I'm expecting from January onwards they're going to move forward again. But how much they're going to move forward, I do not know. But definitely they're going to move forward. But EB3 is going to hold a lot because a lot of people actually downgraded from EB2 to EB3, and those petitions will take some time. That's my personal view. I can be wrong.
So actually on that point, I'd like to ask is, do you think it's a good move downgrading from EB2 to EB3? And who would you recommend that move to? As in, who do you think should downgrade their visas?
If the priority dates are available to you, and then it allows you to file your adjustment of status application 485, then, and that's only available to you by downgrading your I-140 petition from EB2 to EB3, then you should go ahead and do it. The reason why I would say that is filing 485 is very, very important because it allows you to stay in this country. If something happens with your job or with your employment, and if you lose your H-1B status, then you have to depart this country immediately. If you're H-1B or L-1, whichever non-immigrant status you are in this country. But downgrading I-140 petition, by downgrading I-140 petition, and if you file 485, irrespective of the status of your employment with the current employer, it authorizes you to stay in this country. Then you can find a different employer, and then you can port your green card to a different employer under the AC-21 portability regulations, which allows you to port your I-140 after 180 days of pending your 485. Okay, so that's why you should downgrade your I-140 when you have an opportunity to file 485 along with the I-140. Otherwise, I don't see the necessity to downgrade, but in the end, it's an individual preference, how you want to handle your green card processing.
Right.
Or how the company wants to handle their employees' green card processing.
Right. So my last question is, what is a priority date in relation to NVC?
As I said, NVC, as I said, they process the applications based upon the request made by the Department of State to them. For example, if Department of State assumes that they're going to move dates forward for the next 6 to 7 months, then they may advise National Visa Center to start processing for those cases which have been required for the immigrant visa processing. And then that's how they usually start. most of the times the NVC priority dates are same as the Department of State priority dates. So they both are same actually. There's no difference between the both priority dates.
Right, right. So that brings us to the end of the session this time, Mr. Bhanu. It was a privilege hosting you, and thank you for all the information, that valuable insights and wealth of knowledge that you share with our viewers and us.
It's my pleasure. It's my pleasure, and thank you very much. Thank you, Sakshi team.
You're watching Sakshi Live with me, Torini Makana. Thank you.